2 days ago, the family of Corporal Ivan Wabwire, the police constable who shot dead Uttam Bandhari, a money lender in Kampala last week, said their son had a mental illness.
He was hospitalized for 6 months in Butabika Hospital. Afterwards, he was given sick leave and he lived with us for 1 year before he was redeployed.
George Musisi, a human rights lawyer, says in an insanity defense, although the defendant admits to committing the crime, they cannot be charged because of mental illness.
You could have committed the crime when you are insane or when you're not capable of forming the necessary intention of committing the crime, or you could have been sane but you have lucid moments that at the point of trial you're not capable of understanding what is going on. The duty is upon the person who is alleging it or his or her legal team to prove to court that indeed at the time when they committed the offense, they had mental health issues.
Last week, Patrick Onyango, the spokesperson of Kampala Metropolitan Police, admitted that Uganda Police Force was aware that Wabwire had a medical condition which he did not disclose.
Due to the suspect's medical conditions, police management at CPS Kampala had taken the decision about 6 years ago not to arm the suspect, not to arm Wabwire with a gun.
Musisi says that in his comments, Onyango might have inadvertently created an excuse defense for Wabwire.
At the time of trial, certainly this man might be having a proper defense, and police, in its haste to give a comment, may have helped him in forming that defense. So the subsequent comment from the police spokesperson sanitizing it and declaring him healthy or fit, it may look like an afterthought, which is meant to meet the requirements of expediency to ensure that this person undergoes a trial or that there is some justice which is seen to be done.
Geoffrey Turiamusima, who is Wabwire's lawyer retained by Uganda Law Society, admits that pleading insanity will be their first point of defense.
There is history of his mental disability and the police is aware of the same. That is one defense which we are going to rely on. And we are sure that by the time he was committing that offense, he was mentally not okay.
Wabwire's family claims he developed the mental condition while in training at the police training school in Kabalye, Masindi district. The fact that the police continued Wabwire's training and eventually deployed him could have been a negligent act that endangered lives.
Because mental health is a whole big issue at the workplace. But in this case, the danger is even higher because the person might have access to killer weapons. I don't know whether that deployment, maybe to CCTV or to ICT, doesn't require someone to have full mental faculties.
I think what police ought to have done, especially getting to know of his mental disability, either they would have discharged him from police or they would have not given him even a uniform.
Musisi says that when a defendant successfully pleads insanity, they cannot go completely scot-free.
They commit him to a mental health facility. They don't release him to the public. It doesn't have a time frame because it depends on the sickness and the nature of it. Some may be permanent, some may be temporary.
In the law, Uttam Bandhari's family is within its rights to sue the Attorney General for wrongful cause of death, given that Wabwire is a state agent and the weapon used in the murder was issued by the government. Gillian Nantume, NTV Tonight.